welcome to another edition of The Naked Truth. I'm Ramon Rowan.
My name is John Singletary.
And this is being brought to you by Concerned Citizens Alliance, where our mission is for economic empowerment, social justice, as well as education through the dissemination of information. Thank you for watching. Today's title is Houston DA Encourages Blocking Blacks from Juries. John, we spoke about this a couple years ago. Now, I believe it was last year, about juries and how that we have about that the lack of black representation on juries. Many times, when we looked at if you look at the study called The Myth of the Colorblind Judge, we see that there is much more. Believe it's 90% of all judges in the United States, state and federal, are white. And so you're not being represented on the bench as far as the judges, but now you also are not being represented in the jury, on the juries, because you're supposed to be, according to the law, is that we're supposed to be judged by a jury of our peers. Now, when you have a black victim and a black defendant, and you're saying that, and you're looking on the jury, and you see nothing but white people. Mm-hmm. And so there's a difference. I mean, when we look even in the education center, a black teacher and a white teacher, they treat their kids different, because the black teacher understands that black child than the white teacher does. But the fact is that in this DA, what they were just doing was they was encouraging their assistant DAs to strike off black jurors. And John and I had this conversation a couple of days ago, to where they don't want, especially the educated blacks on juries. They don't want those, because the educated blacks are going to be more thought-provoking, more cerebral, and the fact that you're going to say they're going to challenge the whites that are in that jury. Because most of the white, one thing, white man, at least here in the South, they don't want to be challenged by an intelligent black man.
The Batson versus Kentucky case back in 1986 was one of the cases, the seminal case, that said that you cannot use race as the deciding factor to whether you put someone on a jury or not. Can't do it. And so this DA is working around that and still not allowing people to be judged by a jury of their peers. When we look at Article 3, 6th Amendment, the 14th Amendment, clearly allows you to be judged by a jury of your peers. Yeah. The 14th Amendment, because previously it was confined to the federal cases, allowed the same to happen within the states in terms of the jury of your peers. When we take a look at the process that the attorneys go through, called a voir dire, in order to select the jury, you should be allowed a fair opportunity. Back in 2012, when Trayvon Martin, Sheldon Singletary got shot, killed, there was a jury that was unfair. We brought the issue up then because we looked at and did some research to find out it's not the attorneys per se and the process that they use in terms of voir dire selecting, but the racism ingrained systematically in the process happens much further downstream. Mm-hmm. It happens when they compile the list that the attorneys choose from. Mm-hmm. So when the list is compiled, they weed out many blacks who should be on the jury. So when the attorneys then choose, then they're already choosing from a tainted list. And so it's inevitable that those kinds of things are going to happen. There was, in the 70s, a thing that came along that was called jury selection, where they actually did it through psychological testing, and I can't remember the exact name that they called it, but it was a process that they used in terms of the jury selection, where it was supposed to be down to a scientific jury selection. That's what they called it, scientific jury selection. And it's heavily used to make sure that you put the type of people on the jury to get an end result. You are guaranteed in the Sixth Amendment the right to trial with no delay. You're guaranteed the right to an attorney. You're guaranteed a right to an impartial jury. So how do you get an impartial jury if in fact it has been tainted by putting certain people on there and certain races on there? You're entitled to have, to know your accuser, as well as to know the charges. When we take a look at what happened with the Dylan Roof case right here, the judge said, yeah, you got all of those things, except they didn't give you number 6. They didn't get number 5. They didn't tell you what your charges were. So because they didn't tell you what your charges were, now we're not going to allow you to plead guilty. You can't. I'm going to take your guilty plea and turn it into a non-guilty plea. Now you have the right to come in and try and plead an insanity defense. Boy, you're going to live. Because see, if previously what they would have done is, if they would have accepted the guilty plea, he would have had to been killed. And so those are the kinds of games that they play to work around the system. We must have our legislators and the people that we put in office to take a look at these kinds of things that the DA did. When you take the system and you remove the integrity out of it, jury of your peers, then what do you have left? You've got a system that is tainted, that people can't trust, there's no integrity in it, and actually what you have is mob rule.
You can look at historically, you can look at many cases throughout the years and look, and these we're talking about recent cases, such as the Trayvon Martin case, is that you look at how many blacks were on the jury. You look at that and you say, wait a minute, you know.
And the makeup of the town.
Yeah, and the makeup of the town, right. So when you can, if you can eliminate them on the pool, so you got less to select from, so now it's already tainted. So when we're wondering, how did the jury come up with this decision? And you say, wait a minute, let's look at the demographics of the city or that town, and let's look at the demographics of the jury. Now, when we look at and historically, you can look at what's the case with Emmett Till. You know, that case. You know, they found those guys innocent, but guess what? There's Tenney, the guy Tenney here in South Carolina. George Tiny, right. When that trial happened, it was all whites. Blacks at that time could not even sit on the jury.
Absolutely.
In that town. You know, so you say, well, all the white, you know, you convicted a young boy, I think he was 13 years old, to death by an all-white jury. So this has been happening for years. And when we look at when you're getting called for a jury, blacks get called for a jury, a lot of people they don't want to serve a jury.
It's a responsibility, and we have to take it seriously.
You have to take it seriously, and you got to say no. If you don't sit on that jury, if you don't be the one, then this man or woman can be convicted of a crime they didn't commit. And I was looking recently on exonerations. People being exonerated. 75% of those are minorities. 75%.
I sat on the jury one time, and we had on that jury we had 12 people. We had 6 whites, 6 blacks. We had 6 white men. 3 white men, 3 black men, 3 white women, 3 black women. And when we started talking, initially it was about 6 and 6. Eventually, they tried to move the conversation to dealing with education. Of course, more whites on the whole in the room are educated, and so they tried to say, based on their education, their decision was right. And we had one guy, he said, listen, I graduated from the Citadel about 4 or 5 years ago, and he just went on and on and on and on. And,
The white guy.
right. And and he know about these kinds of things. The white woman said that, well, she had a hair appointment, and that what she needed to do was, we needed to just go ahead and convict him, because we don't need to stay there all day, because if he didn't do that, he probably did something else. Now, I'm telling you what happened in that.
Right.
And so we went on and on, and I said, listen, the fact that you guys graduated from the Citadel, that's fine, that's not a problem. I said, I graduated from Citadel back in '83, so long before you even came along. But that does not make me right in this decision. We have to take a look at the facts. We debated a while, we went to lunch, and we came back. By the end of the process, we had 11-1. Now, I wasn't moving.
Mm-hmm.
I wasn't budging, because the evidence that they put forth just simply was not sufficient to convict anybody of anything.
Mm-hmm.
They couldn't even put the guy at the scene, but yet they were willing to convict him.
Right.
They were willing to convict him because he had dealt with drugs.
Mm-hmm.
But what they were saying at that time, there's no way the young man could have done that. They just wanted to get him off the street. So we ended up with an 11-1 hung jury.
What shocked me is the fact that one of the jurors said they had a hair appointment.
Yeah, and if he didn't do that, he probably did something else.
Oh wow.
Here's a young man who's got a family
Mm-hmm.
that, no matter what his past was,
Right.
what they were trying to convict him was on a murder charge, someone who got shot, no blood at the scene, they couldn't find any bullets, they couldn't find him attached to a gun or anything. Yes, in trying to convict him. And so we must, those of us who have been fortunate enough to have some education, we've got a responsibility to not shun, but to be on those juries, because that helps to keep our young boys out.